Ms. Rivers, are you ready?
Yes.
Okay, going on the record in just a moment. Let's see if those cameras work now. Oh, okay. Are the screens off, Deputy Gordon? Or
It's just you on the screen.
All right, lucky them. Okay. This is 24 PI 008680, State versus Ricky Hutchinson. Good morning, Mr. Hutchinson.
Good morning.
I'm Judge McBurney. Your case has been assigned to me just to talk about bond. So Mr. Cozzoli will represent you for bond. If your case gets indicted, it will probably go to a different lawyer from his office. We'll probably go to a different judge in this courthouse. It'll be randomly assigned, and that judge is going to have his or her own public defenders who work in that courtroom. But as long as what we're doing is talking about bond and you haven't been indicted, then Mr. Cozzoli will be helping you with that, okay?
Yes, sir.
I'm going to hear from him in just a moment about why I should set a bond for you and what that bond should look like. And then I will hear from Mr. Abate, who is the prosecutor, who right now, Ms. Johnson, you need to mute your phone, about the state's perspective on that. And I'll let you know what I'm going to do. If I do not set bond, that doesn't mean we can't talk about it again in the future. If I do set bond, then you and your family will need to figure out how to make that bond. Yes, Mr. Cozzoli, when you're ready.
Thank you, Your Honor. Your Honor, Mr. Hutchinson is 21 years old. He has a good address at 2405 Spring Creek Lane, apartment 2405. That's going to be in Lithonia, Georgia. He lives there with his aunt. He was born and raised in Georgia, Your Honor. He had 2 jobs at the time of his incarceration, and he has been able to confirm to me that those jobs are still available to him upon release. It's going to be at Quick Draw Towing, and he also works as a cook at Culinary Drive. It's Culinary Drive? Culinary Dropout. Your Honor, he is a high school graduate. He's also attended trade school at IBW. Your Honor, my understanding is that Mr. Hutchinson has limited to no previous criminal history. Your Honor, I would be happy to hear from pretrials if that is not the case. So our request, Your Honor, is for a reasonable bond to be set here. Again, there's nothing in his history that indicates he's a general danger to the community, a general danger to the victim or the victim's family. Him being a lifelong resident of Georgia, Your Honor, there's nothing in his history to indicate that he is someone who will flee the jurisdiction. So we believe, Your Honor, he is entitled to a bond based off those factors. Our request, Your Honor, will be a bond of $75,000. We're going to be requesting, Your Honor, $50,000 on the murder charge, $15,000 on the aggravated assault, and $10,000 on the firearm charge. Nothing further.
Okay. Ms. Jackson, I think we've fixed the volume issue here in court. Can you share with me, please, criminal history information for Mr. Hutchinson?
Yes, Your Honor.
You sound great.
Can you hear me, Your Honor?
Yes, you sound great.
Okay. He has 4 cycles. The last arrest was September 6, 2024 in Douglasville, Georgia for a probation violation. He does have a misdemeanor conviction and a sentence. It's one in 2023 out of Conyers, Georgia for a non-fingerprintable offense, and one in 2023 who received a nolo contendere sentence out of Douglasville for driving while license suspended or revoked. Nothing in addition, Your Honor.
Thank you so much. Mr. Abate.
Yes, Your Honor. I have the same similar criminal history. The defendant has minimal criminal history as it relates. He has no felony history, and the history that he has is all misdemeanor arrests. I do, as it relates to risk of flight, he does have in his GCIC 1 failure to appear that was fairly recent in May of 2023 in Douglas or Douglasville. but it appears that that has been resolved. Your Honor, I would submit to the court that based on the facts and circumstances of this case, the defendant is a risk as it relates to the community and the people within it. Based on the circumstances of this case, on November 24th of this year, the defendant, his friend, Mr. Devon, had gotten into an argument with the victim. There was a physical altercation. The victim in this case was unarmed, and it was merely, fist to fist. This defendant decided to pull a firearm out and begin to obviously shoot at Mr. Johnson, killing him on Crescent Avenue here in the city of Atlanta. Upon officers,
Crescent, as in Midtown?
Yes, Your Honor. There was a nightclub, one of the nightclubs that's off of Crescent. They were all waiting in line. The associate of the defendant, Mr. Devon, after speaking with the police, didn't believe that there was any need for any additional force that he had to taken care of, is basically what he said. And he actually said during his interview that he didn't believe that the victim actually posed a serious threat, as he was intoxicated as well. And that the use of force that he saw his friend use as it relates to Mr. Johnson shocked him, and he was unaware that he actually had a firearm. So the state would, based on the facts and circumstances and the fact that this defendant took it within his power to, in the middle of the street, fire a gun around a crowd of people at this time, makes him not an appropriate candidate for bond.
And I appreciate this is all very preliminary, and Mr. Cozzoli's probably seen zero evidence in the case, but what is it about the facts that you believe connects Mr. Hutchinson to the shooting? It would be Mr. Devon, the eyewitness, saying, look, we were all standing there and there was this dispute between Johnson and Hutchinson, and here's how it ended.
That, Your Honor, as well as there is some video surveillance evidence. The actual shooting is not on video surveillance, but within seconds of the shot being fired, there were several City of Atlanta police officers who were working off duty at the surrounding clubs, and they immediately surrounded the defendant, and he was actually arrested and captured with the firearm, physically in his hand.
Good.
And when Your Honor deems appropriate, as you're aware, Ms. Johnson, the mother of the victim, is on the Zoom and would like to make an impact statement to the court.
Of course, that is very appropriate. And Ms. Johnson, if you want to unmute now, and if you turn your camera on, I'd appreciate hearing from you about your thoughts about bond for Mr. Hutchinson. Thank you for being with us.
Yes, sir. I just wanted to say thank you for letting me have this time to speak. My son was 28 years old. He's never been in any trouble. He came down there to have a nice time with his girlfriend, brought her down there for their vacation, for her birthday.
When you say, I'm sorry to interrupt, but so your son was from out of town or just from outside of Atlanta?
Yes, we from Memphis, Tennessee. We stayed in Memphis, Tennessee. I've been working for FedEx for 23 years. He followed in my footsteps. He worked for FedEx when he got out of high school. I never had to go to the school for my son. He's never been in any trouble. And I just don't know what happened that night, but I just feel like, that he doesn't need a bond.
Okay. So your son was in town with his girlfriend. They were just enjoying things, taking a break from Memphis. And that's when this happened.
Yes, sir.
Okay. Well, I'm very sorry for your loss, but I also very much appreciate hearing from a family member and getting that perspective. Thank you.
Thank you.
You're welcome.
Nothing further from the state, Your Honor.
All right. Mr. Cozzoli, I always give last word to the movement, and that is you. Anything you want to say in connection with what you heard from Mr. Abate, or anything else that you wanted me to hear?
Just briefly, Your Honor, I did just want to note for the court that Mr. Hutchinson has his preliminary hearing tomorrow. You were correct in saying that I had not seen any of the evidence discussed today. Even the evidence provided by the state statement, I have not heard. My knowledge of the incident is just the probable cause section of the warrant at this time.
Sure.
So, Your Honor, at this point, these remain accusations, and they remain testified to through a warrant, but with no chance of cross-examination at this time, Your Honor. And more importantly, Your Honor, we believe that the ILL factors must speak to something other than the allegations for which Mr. Hutchinson is here for today. I will note, Your Honor, that Mr. Hutchinson also does have family present as well and support.
Yes.
Nothing further.
So they've been here all morning, and I appreciate that, and that's a good sign. Mr. Hutchinson, I'm not going to set bond at this point, but I am going to invite Mr. Cozzoli to circle back after tomorrow's preliminary hearing. I think he will understand much more about the facts and circumstances of what happened on November 24th. I will tell you that what I'm most concerned about is the notion that it sounds like there's going to be self-defense. And that's what I suspect you'll be exploring with the officer and whatnot. And so we'll need to suss that out a little bit further. It could reach the point where there's an immunity motion filed. But until I hear a little bit more about that, I'm hearing about one gun being recovered on Mr. Hutchinson and not a whole lot else. And that gives me pause about Mr. Hutchinson's safety and the safety of those who might be around him if there is some disagreement about something. I don't find that he's a risk of flight. I'll be clear about that. But based on what I've heard, I want to let the preliminary hearing play out and then give you a chance, Mr. Cozzoli, to circle back if you think there was evidence that came to light in those proceedings that you think I ought to see or hear. I could read the transcript, or I'm happy to rely on representations by counsel on both sides. Mr. Abate won't be the one doing the prelim, but there will be an attorney there. And if after that prelim, the things you want to share with me, an email to me copying whoever your counterpart was at the prelim and Mr. Abate, it can be that simple to say, Judge, you should know X, Y, and Z. Then I can figure out how to get a transcript, or we can reconvene. I don't mean for this to necessarily be a forever answer. And I want to add this, Mr. Hutchinson. The state has a certain number of days by which to indict you. And if they do not do it by that date, then you are entitled by law to a bond. So my concerns that may persist, it may be after the prelim tomorrow, Mr. Cozzoli says to you like, this one's kind of complicated. You're absolutely entitled to a bond if we reach that 90-day point and there's no indictment. That would again come back to me, and we'd work through that. And Mr. Cozzoli would be reaching out before day 90 to say, hey, we're at day, I'm making it up, we're at day 80 and there's no indictment. So please get us on a calendar so you're not waiting after day 90. We get it on the calendar, and it would just come off the calendar if it does get indicted, because then this question about bond would go to whatever judge your indictment is assigned to. Does that make sense?
Yeah, I have one question.
Sure, as long as it's not about the facts of the case.
Okay, so after the preliminary hearing tomorrow, there is a chance I could get bond?
Sure. Mr. Cozzoli will know more about the facts, and he will be in a better position to say, I heard what the state said, but what you didn't hear from all that was, I'm making this up, Mr. Hutchinson was shot twice before he did anything. That's a very different scenario from what I'm hearing, and I'm not making any factual findings, that there's a disagreement, maybe they're shoving or pushing, and all of a sudden one guy pulls out a gun at a fist fight. That's concerning. You can understand why I'd be concerned if those are actually the facts. And Mr. Cozzoli, through no fault of his, he's not able to push back on that yet because he hasn't had a chance to talk to anyone about it. Tomorrow, there ought to be a detective there that Mr. Cozzoli can ask questions of. Well, what about this? And how did this play out? And so your lawyer will then be in a better position to say, Judge, there's more to the story than what you heard. Okay. So yes is the answer. It's a long way of saying yes, that we can revisit it. And even if after that hearing, you and Mr. Cozzoli talk and Mr. Cozzoli says, it's just, that didn't go real well for us. All the evidence was that you shot this guy. I'm again making it up. You shot him in the back. That's kind of hard to argue self-defense. If it gets to day 90 and you're not indicted, no matter whether the case is good, strong, ugly, or upside down, you're entitled to a bond. So there's also that maximum deadline where if it's not indicted, we have to reconvene, and I'm required to set a bond, which of course I'll do. I'll do what the law requires. At this point, I'm going to table it and not set a bond for you. We'll let you and Mr. Cozzoli get through the prelim, and then if Mr. Cozzoli thinks that we ought to discuss this further, it could just be emails, it could be he wants you to be in that loop, and then we'll get you back in court, or he can always waive your presence in this sense. You'd zoom in, so you'd be able to see and hear. You just wouldn't physically be here. You'd be in one of those Zoom booths out of the jail. Okay? Did that answer your question?
Yes.
All right. Pardon me?
Not my money.
Sure.